Thank you, Peggy, for that fine introduction. I think this is an excellent series, and I've got to admit to you, I think I've got the most boring part. The first part of the series, you heard a lot about the practical aspects of the type of living wills and medical powers of attorney, and I think that is a very important thing to know. In this part of the series, you're going to hear about the paper, you're going to hear about what you can do legally in terms of your estate plan, but I would highly recommend that you attend the third part of the series, because it's only when you attend the third part, when you hear about the values that you want to pass on as part of your legacy, that I think you can put all those pieces together. So the first part and the second part were kind of the how to get it done, but it's the third part that's going to have you thinking about, well, just what it is that I want it to do. So once you have your goals from the third part, we're going to work today to show you how you get there. Just like as if you're going on a trip and you want to know if you're going to be traveling by bicycle or by car, it kind of affects how you decide to approach the trip. So we're going to show you how to approach the trip. Now, I call this winning the estate planning game because we're going to liken it to a game of tic-tac-toe. Now, if you remember how to play tic-tac-toe, it's really hard to win. But in this game, you can win by lining up your three pieces all in a row. And those three pieces are your wishes, what you want to do, the documentation, that is the paper that talks about what you're trying to do, and the law that applies the paper to accomplish what you want to do. Now, everybody know where they are on the handout? All right. So the first thing you've got to be giving some thought to is what it is you want to do. People plan for all kinds of reasons. The one that Peggy brought up today is the Terry Schiavo case that is so much a part of the news these days. A lot of people plan so that they avoid contests. They avoid arguments between family members, and so that they can protect their own dignity in order to be able to make their wishes come to pass without causing any further disruption or disharmony among the people they love. They also plan in order to protect their loved ones and to provide for them. So when you have something and you want to make sure that something is used to be able to take care of the people you care about, you often need to be able to put a plan together to make sure that that's what is accomplished. And the people we want to plan for include the people we were married to, our children. If we're minor children, we need to plan for who's going to help take care of them, as well as who's going to take care of their money. But even if they're adult children, we might want to plan for how to keep it in the family and away from a divorce. We might want to plan for how to keep it with our loved ones and not in some sort of lawsuit that our loved one gets involved in. We can do all that kind of planning. And of course, then there's the blended family situation, the Brady bunch. So how do we deal with the yours, mine, and ours situations? Because the law really does not cover that one well at all. So when you have a blended family, you definitely need to be doing some of your own thinking about what you want and put it on documentation, because the law will make different assumptions than most families do in that situation. Part of planning is to promote your own personal values. Now, of course, providing and protecting for the people you care about is one of those values. But you might also say, well, I want to make sure that the people I care about get a good education. So you want to make special provisions in your plan for that. I want to make sure that the people I care about who have an addiction problem don't use it to further their addiction. So we need to make plans for that. Nobody really has a beaver cleaver family. So I get questions like, can I do a simple will? And I'm like, well, yeah, if you have a simple family. But I don't know too many of those. So we've got a plan for the people we have, and the needs and the wants and the fears and the hopes that they have and we have for them. And that's all about the planning. Then there's promoting community values. In your plan, you may want to make sure that your community has some legacy from you in terms of even money. Are we leaving them something to accomplish through the senior center? Are we going to accomplish something by building a park? Are we just going to leave it to the charity that we've always supported? Is it going to be something to our church? Those are all kind of things that if we don't plan it and we don't document it, it's not going to happen because the law doesn't presume it's going to happen. And towards the end of this program, I'm going to talk about saving taxes. Okay? Because people think that's what I do most. but it's actually what I do least. If you tell me where you want to go in your plan, then I can make sure that taxes aren't a roadblock there. But if all you want to do is save taxes, well, I'll tell you right now, the secret to saving estate taxes, don't have anything. And if you have it, leave it all to a charity. That's it. There'll be no estate taxes due. But we're going to talk some more about that. Okay? Now, the second piece of the puzzle is documentation. That is the pieces of paper that talk about what your wishes are. And this is where a lot of confusion comes about. So let's talk about the traditional documents used and some of the more typical documents used in a trust-based plan. So the traditional document was a will. Okay? Will is a piece of paper. Within that will, a lot of people wrote for a trust. In that context, it would be called, by lawyers, a testamentary trust. So a testamentary trust is one that comes into effect after you die. So how do you remember that? Well, think about this. You've got one of those old World War I, World War II movies. I don't really care, because they almost all have this scene, and there's the soldier, and he's in the foxhole, and he's filling out his last will and testament. Come on, you can talk. Okay? So if he's filling out his last will and testament, that's something that comes into effect after he's dead. That's a testamentary trust. And a lot of people who have a will have set forth some sort of trust that will be built after they die. It may be to protect for their loved ones. It may be for estate taxes. It may be because there are minor children involved and we can't just give them a check. Those are all testamentary trusts. Now keep in mind that this trust doesn't exist while you're alive. All your will does is that it's the blueprint for how to build the trust after you've died. And then we want to talk about powers of attorney. Powers of attorney are documents that name someone else to make decisions for you and to act for you when you can't. Now, powers of attorney come in two flavors. You may have one power of attorney that does both these things, but you can also have two powers of attorney to separate these things out. The first type of flavor is the legal and financial decisions we need to make in our life. You get a check. You can't sign it because you're sick. Who's going to sign it and put it in the bank? You need to sell the house. Who's going to sell the house? Okay, those are the kind of things that a legal and financial power of attorney names someone to do. Then there are medical decisions. Who is going to make medical decisions for you? That's a medical power of attorney or a health care power of attorney. And that's part of the advanced planning or advanced wishes documents that were talked about in the first part of this series. Also part of that advanced wishes document is called a living will. Now this is the dumbest name because it has nothing to do with living and it's not a will. It's not. So let's talk about what it is, okay? It's the document that tells them what kind of treatment you want at the end of life. So one of my clients, he said, well, let's be blunt, Karen, you're talking about the pull the plug document. I said, yeah, pretty much. Do you want that? Do you not? And when do you want it? Okay? So the first part of the series went into that in depth. But that is really, when we're talking about planning for death and disability, it's a natural consequence to start to talk about the kind of care you want. If you weren't at the first part of this series, I would suggest you take a look at it when it comes out on video. But more importantly, I want you to look at the documents you have, because this is an ever-evolving area of medical and legal issues. So if you did a document a while ago, you might have done one that's one page. It says, if I'm terminally ill and you can't talk to me for 7 days, turn off all the artificial life support. Well, let me warn you, that document would not have helped Terry Schiavo because she's not terminally ill. She had a persistent vegetative state. Now, the 5 wishes document, which is one of the documents that came up in the first part of the series, would have helped that, would have made her wishes more clear, because it asks about that. You can list a persistent vegetative state as one of the things you want, or a coma. Now, remember Terry Schiavo, but if we're all here, myself included, are old enough to remember Karen Ann Quinlan, that started this whole right to be able to make these decisions. Her parents went to the Supreme Court because she was in a type of coma, not really a persistent vegetative state, but a coma